I show you some colorful pictures now, trying first of all with an introduction to get a little bit closer to the investor protection area. Where do we all stand here? That we are all, so to say, on the same page of our understanding, and what we have learned already during the day, and I find it always very interesting and fruitful, is that such a number of different jurisdictions, of different countries' experience and so on, brings in, the real variety of what it means that European uniform rules are implemented in such a, on the one hand, different way, but on the other hand, there needs to be a common understanding, and we try to see what in the investor protection world this means. Just starting with the most similar slide I always used to start with, what we are just talking about here, just to remind us, and I try to keep it short, just to remind us of what is this all about. I mean, this is, other than governing the trades and the marketplaces and so on, this is about investment services. Investment services is the key term, together with the financial instrument. Generally, all the investment services which qualify for MiFID and MiFID II terms belong together with financial instruments. And what I've just simply going to show you here is that this is just a normally three-partite scenario when you got someone who has a product to be brought to the market, be it what we call an asset manager, a fund company, then the distributor or intermediary as an investment advisor, as a broker, as a portfolio manager in that sense of individual portfolio management, and of course client and the investor. And where we got the red line, just the dotted line around, this is what is generally the focus and the subject of MiFID and MiFID II rules. This is the investment service, this is the relationship between the intermediary and the client, and this is an intermediation regulation, generally speaking. And as we all have learned and all know, and are going to look at now a little bit further in more detail, product governance moves on to the product in a way we have a look at. And on the bottom you see, just another, depending on if in your country, in your jurisdiction, markets are different, but in a market like Germany and others, as far as I know, there are also situations where you just, where you have the classical buy-side, sell-side situations where you have a special fund, as we call it, and you deal directly with an investor. And then, of course, the question may arise whether this is an investment service at all and whether this is not relevant for MiFID purposes. First of all, of course, it needs to be an investment firm, and this, of course, from the definition, belongs together with the provision of an investment service. And just wanted to remind you that according to Article 4 of MiFID II, the definition of execution of orders on behalf of clients has been extended, that it includes the conclusion of agreements to sell financial instruments issued by an investment firm at the moment of their issuance. So it is more likely than before that the product manufacturer in the bottom example can provide an investment service other than under MiFID I. And I believe this has been done including for the purposes of covering those people with product governance rules. This is not really legal or regulatory, this is just a mixture of, and we should be aware, and I'm talking quite a lot to people who are not lawyers and not regulators necessarily, about what are we doing here, what is this regulation about? And I would believe, irrespective of where you're from, or from the west, the east, the north, or the south, that most of these issues are common for you. These issues are part of market practice, of developments, of things to come, with the zero interest rate environment for the past years. I'm not assessing anything, I just try to give you a set of facts, and this of course then leads to where can I get return, where can I get performance, costs. I mean, if I got 5% interest rate and I can get a bond fund and make performance, irrespective of inflation rates, of course cost of 1% is different than an environment where I got even 0 or 0.5 return from bond markets, for example. And then it comes to other asset classes, and things become more digital. I've learned that everything that can become digitalized will become digitalized, and robo-advisors, some of you and many of you will at least heard of them and know them, possibly also from your country. So one thing comes to the other, and then the ETF as the for some people, the ideal solution in this world. Low cost, no distribution cost involved, and everything works. I'm not sure if this is the case. So all these things go together, and these issues, so to say, characterize the market environment, and then MiFID II comes in and leads to certain consequences, including, as I would believe, unintended consequences. And I think we can try to figure out today, the rest of today and tomorrow, in which respect we have an idea, a view, or agree even where things are going into a direction which, of course, a regulator, a legislator normally cannot anticipate, and markets, act their own way, and investment firms react their way. What is it all about? I mean, I had the pleasure to be a part of a working group at ESMA for 4 years, from 2013 to last year. Now I'm cooling off a bit and try to come back next year. So this is always for a 2 years term. And we had discussed there, and I had the pleasure to participate with regulators and ESMA guys and ladies, of course, the rationales behind. And if you would like to cut it down to one point from my perspective, from my perception, what is the real reason, why MiFID II investor protection rules are made the way, including by the way ESMA has detailed them, and this, of course, has caused discussions and has caused contrary positions from national authorities and from national associations, lobbyists, and so on. I would put it to the example on the left-hand side. We will talk about inducements, and I will personally do it tomorrow, so I just pick it up briefly. It's all about the situation of conflict of interest between the client and the investment firm, and of course, if you would like it, the product manufacturer. And you cannot really get rid of that conflict of interest. You just need to be aware that it exists, and then you can try, in particular from a regulatory perspective, to deal with it somehow. Some countries, I mean the UK, the Netherlands, have introduced their own way of dealing with it, complete ban, or more or less a complete ban, commissions, together with other important topics which come across. MiFID II has done it differently somehow, but I believe if you look at the left-hand side picture, of course, this is a exaggerated and more black and white way, but it just shows, in a very specific way where the conflict of interest can come from, and that just people, I mean, that's how the human brain works. That's what I always say. If you're incentivized somehow, then you act according to that. I do it. Everyone generally does it. And Markus Ferber, his conviction was that he wants to have the products made for the client and not only for the investment firm. Of course, this is all a bit, in a way, put to the sharper point. If we look at those key concepts which MiFID II, we are not addressing everything in these 1.5 days. That's what we are aware of. But if I have a certain kind of good selection of points, I would make these ones, and they come back in a slide a few moments later with a kind of status quo report from what we have experienced from a lot of projects with clients and engagements with clients. What have they done and what they're doing these days, not only in Germany, also abroad. I mean, these are, as I would say, key concepts. As I said, inducements will be covered tomorrow at the end. Now we are going to look into product governance. Product intervention, I think we don't have it specifically this time, and suitability, appropriateness, disclosure, cost transparency, documentation, taping, I think, a recording. These will all come tomorrow in the morning. Yes. And if we look at in particular product governance rules, or with a view to those details we want to look at in a moment, just a very simple overview of the status quo as regards, or the working together, as far as it works together, of 3 different dossiers which have been handled, and this is the way EU law is made. 3 different dossiers of quite important regulations, new regulations, MiFID II, PRIPS, and IDD, the Insurance Distribution Directive. The idea was, and this was brought forward, that there's a level playing field between insurance, in particular investment products, and the normal investment products, so to say, not in an insurance wrapper, called financial instruments. And I don't know how familiar you are with the insurance regulation side. It is also not my kind of entirely favorite topic of expertise, but as far as I've noticed, once again, the insurance regulation is less stricter and will end up less stricter than the securities regulation. For example, due to the fact that the IDD is a directive and it just needs to be implemented into national laws. I mean, the IOPA, the relevant ESMA, so to say, a counterpart player, they are, I would say, as strict and as bullish as the ESMA is. But, for example, in Germany, they quite often fail to get through with their ideas to get it into national law and national practice. And product governance, and they call it POG in the insurance world, as I've learned, product oversight and governance, is a topic that is about to cut through. You may know that there's also an EBA guideline on product governance for banking products, for payment, credit, and account products. For example, in Germany, not many people have already taken notice thereof. It is more or less existing somewhere, you know, below and under the counter, so to say. And we will see what comes up with that. Product governance for insurance purposes has been seen quite hot and as quite important topic by IOPA, and there has turned out, as far as I remember, delegated regulation. So we will see what happens there, and there are many parallels, and it's quite interesting to see. While in other areas like inducements, it is going differently quite largely. Yes, and let's not become too technical once again. We want to look at colorful pictures now. Just, you know, you are all aware of this, of course, and if you're a regulator, possibly more than I am, just the cascade again, and always to be clear, you know, this is what we tell our clients, what will come still, you know, and where do you need to look at, and where do you need to be cautious, and where do you need to be up to date. We have seen in the cascade, and I know how it has worked in your respective countries. MiFID II at the, so to say, first level has been transformed in Germany into an act. It has existed before, it has been amended and recasted, so to say. In Austria, for example, I think there's no one from Austria here, but there we got the WAG, that's a similar piece of legislation. And then at level 2, we have seen the Delegated Directive, I believe, including for the markets aspects. All other things on level 2 have been delegated regulations, including the RTS and ITS. But we got this one Delegated Directive. We come to it later. It contains the basic rules on level 2 for product governance and inducements, as you are aware. And this has been transformed, for example, in Germany into not an act in a technical sense, but the next level, so to say, in German legislation. We call it Verordnung, which is different from Verordnung. It's also regulation as an EU regulation like MiFIR, but this is a, so to say, if you want to say, governmental regulation, which is just one below the act level. And then, of course, we got the supervisory measures with ESMA. That's quite important. In particular, looking at, you know, guidelines and the Q&As, we come to that later. You're all aware, and I don't know how this is handled in your countries by practice, but if you look at the ESMA Q&A on investor protection topics, as far as I know, and I've just looked at it in the morning, now it has 90 pages, and the last issued and updated version was just before Christmas, of course, as a certain present from 18th December. And we see that each time it is being updated, you know, we find 10 additional pages in it. I mean, as we are sitting here and speaking and talking with each other, we, I hope, can all read and understand what's in it. But if you speak to a, so to say, normal German savings bank or banker somewhere in the country, even in Frankfurt, we've made experience in projects where we had foreign lawyers we had recruited for projects. They were only speaking English, and some clients told us, look, we like it, but and nice people, but can we please have the meetings in German? So you shouldn't underestimate, and I don't know how it's in your country, you know, the number of people who can access it and who may have it printed out or somewhere on their iPad or so, and the number of people who really take notice of it may be quite different. And the German regulator, and this leads over a little bit to the right-hand side at the bottom, in Germany, so to say, the Magna Carta of the German regulator in terms of how at the BaFin level these things are making more detailed and more concrete as an, so to say, anticipated way of the BaFin handling these matters. It's not a law in a technical sense. This is what we call the MR Comp. These are the minimum requirements for compliance. This is a bit from a compliance perspective, but it contains normally all the guidelines from ESMA which are relevant. These days we are still waiting for the new issue thereof, and we just are interested to see if this is then 100, 200, or how many pages. It becomes even more and more, and this is then of course in German language. And the German regulator has announced that it will take into account ESMA's Q&A when conducting its further regulatory practice. And secondly, and I think this is what many clients also find quite interesting, you know, and I'm a lawyer, I'm not an auditor, but the question is, you know, where will the auditor look at when the first statutory, in Germany we have a statutory audit on compliance with these rules, you know, under all these on the right-hand side, the things I've shown you there. And then the question was arising whether everything what is in the Q&A also needs to be, you know, you need to tick boxes in terms of section 3, question 1, 2, 3, 4, and 5 in English, and also an auditor, and not necessarily an auditor from that firm you find here on the slide, but any auditor may have a question with, and including possibly my colleagues, may have an issue, sorry, not a question, may have an issue with properly understanding for audit purposes not only German language rules they need to look at, but these kind of English language Q&A. So these, I think, will play a much more important role than any kind of similar paper we have seen from CESA in the past, from MiFID I. And I find it always interesting to discover CESA papers from 2007, 2008 or so, including on inducements and other things, where CESA has set out certain things which even sound reasonable and which were envisaging a certain practice and a certain kind of supervision. But if you ask people in even bigger countries, they have never come across that this has become relevant. But anyway, I think this is what ESMA, for example, wants to change. And possibly just one thing for this slide. In the middle where you find the peer reviews, one of my favorite examples, and I always tell about it when I'm here, but I repeat it again. If you look, for example, at the suitability requirements peer review report, this is now about 2 years old. It has an annex. I mean, and ESMA has investigated with this, and you know, this kind of survey it always does with selected national competent authorities, checking into the area of suitability. And they had a certain questionnaire. You find it in the annex only, and I must admit I only found it by accident, but then I was happy to have found it. ESMA has presented 3, so to say, different scenarios of an investment situation, including with an automated background. And then the NCAs were asked, the 28 NCAs then were asked to assess whether in each of these 3 situations it would find this is investment advice in the sense of MiFID I. And you find the table in the annex with the abbreviations of the 28 countries, and then you find 1, 2, 3, and then yes, no, yes, no, yes, no, and you find at least, I would say, 20 different varieties of if it was investment advice or not. So there you see the variety of applying the law, and how does ESMA say it's the single rule book, and it is supervisory convergence. And I think the second part of it is, of course, a challenge. On the other hand, we all find it a good point that in our respective countries we have a certain way of dealing with our national specialities. Good. Yeah, just briefly again so that you understand my view on things. This is the new MiFID II world, as colorful as it looks and as dramatic as it may be in practice. Starting on the left-hand side here, we got only 2, and the client, of course, arrives at the latest at the point of sale, but including before. You got the product manufacturer. Of course, it can be all the same entity, but if you got an asset manager providing a fund, then this is the manufacturer. Of course, it is normally, and sometimes it's different, not a MiFID firm necessarily. And then we got the distributor. These two, which are generally potentially subject of these rules, and this distributor as a provider of investment services necessarily. And here you see the entire product and sales life cycle is covered. This makes then sense if you look at my slide I had normally first. What was, as an average kind of way to look at it, as far as I understand it, from different countries and starting from Germany, the MiFID I world as it has been implemented and it has been practiced, by auditors, by national competent authorities, quite focused on the point of sale, and everything that happened before generally was not covered by regulatory provisions. Clients, banks had issues possibly with liability, so they were looking at things, they were looking at how do I select my products, of course how do I advise my clients not to get sued and pay for claims of clients for poor investment outcomes. But MiFID II has made it has colored it entirely, starting with the product launch and then going through. And product governance, of course, we will deal with it in more detail in a moment. Talking about inducements tomorrow, we briefly come back to that. And looking at this, of course, I've been asked already a few months ago. Yes, we have heard about that there are first kind of considerations regarding MiFID III. And I said, I've not really heard about it. I mean, certain pieces of the Capital Markets Union, if you look at ESMA's task, which it has received from the Commission to look into costs and charges and performance of funds, which it will conduct this year. This may lead a little bit in that direction. And when I find a clue to a potential MiFID III world, other than that in the provisions themselves, it has set out certain dates when things need to be reviewed regularly by the Commission, I believe it is. I think the Brexit as such may have the strongest tendency to be a game changer in terms of what should be governed by the things, not what we're discussing here, but by those rules we have been discussing just until before the break, all the day. These markets and trading rules, because so many trades will in the future happen outside the scope of these rules, and the idea of the rule maker was to cover them and to include it into the idea of which markets am I regulating, but now we got a different story. So I think this will be quite interesting to see. Yes, and more or less in a nutshell, or as a kind of certain quick result, what would I say about the status quo of MiFID II analysis and implementation to date? Here you find again on the left-hand side my, so to say, favorite topics in the investor protection area, and where I got this kind of red mark in the column of potential strategic relevance. This is what I believe, if you remember the picture just before, what I believe was the idea of the rules to a relevant extent, just to make investment firms strategically consider, am I doing the right things if I look at my clients and if I consider clients' interests? Am I as client-oriented as I should? Am I really providing the right products? Are those products as suitable as they could be? And. Of course, every one of us has an own interest and needs to earn money. That's for sure, but this is just the approach, and I believe it has not so much to do with the financial crisis. The market pieces have, but I think these are more kind of general considerations, what could be done better in terms of safeguarding investors. And if I tick those boxes, inducements tomorrow, and the other things possibly we can discuss tomorrow in the course of the other sections, I mean that when selecting products, when recommending products, considering what does it mean if the product cost is, the product is 100 and the product cost is 5? You know, what does it mean? Is this really a product I should just let my clients buy? And this can be strategic, because then I need to change to products with only 2% cost, and these may be different ones and from different providers, and of course I may earn less, and then I need to consider where to get the money from, and. And what I would say, this is in a black and white way. We have noticed in Germany, I would say that the same goes for Austria largely, that everywhere, as of today, where you face these strategic issues, of course, the investment firms, and I don't say banks, I just say investment firms, and there are many involved. The investment firms have quite early taken notice of the strategic threat which has arrived, potentially strategic threat. And we have seen it when ESMA has tried to make it a bit more threat, you know, and then others have argued that shouldn't be. Then, of course, associations and lobbyists, and this is all their job, that's all fine, they have intervened, and this has then led, from my point of view, to the rules becoming more and more complex. Sometimes they have not been so complex in the beginning. They have turned out to be complex at the end, as of now, for the purposes of possibly avoiding, for the time being, the need to answer the strategic question. So it has been circumvented, and now it is still an operational question. It has been handled as an operational question. Inducements is the best example under MiFID I. I have found an old article of 2008 in a German legal magazine where the author, who was a lawyer in a big bank, was just putting forward the idea that inducements, sorry, it's tomorrow's theme, but anyway, inducements may no longer be permissible, because this is has been a general rule already, with exception. And what this may mean. And at the end, he argues that possibly life can go on as before, and life went on as before at the end. And in 2015, people sometimes didn't even remember that inducements were not allowed generally. They were not aware, because the exception was so big. So you handle it operationally, you know, by recording, by documenting, and, but you didn't need to change your business model. And when I see on the right-hand side the operational complexity, you know, and product, and those which are not strategic, I took the arrow to the right-hand side in terms of, you know, this is complex, of course, as the rules are complex, but where it has a strategic impact, or at least an intended strategic impact, operational complexity has arrived at a maximum, I would say, generally. And this may, at the end of the day, unfortunately, lead to the unintended consequence for all of us, that what has been meant strategic and could have been answered quite easily through the circumvention and the operational overcomplexity ends at the business model is no longer valid. But that's then a pity, and it has cost a lot of money and has brought no benefit to anyone. Let's see. And we can now try to look at all these kind of theories specifically through the angle and at the perspective of product governance, please. So far, any kind of amendments, corrections you would like to make? I was not too specific enough, I believe, so now we come to the points. Yes, we all know that this is a new regulatory concept. Sorry. In Germany and in other countries, I know this has not existed before from a regulatory perspective. We have made some years ago some internal investigations in German banks where they had a problem with Lehman products. When they had sold Lehman products to retail investors, those certificates, how they were called in Germany, and of course they were suffering the loss from the issuer of the Lehman Brothers entity. I think it was a Dutch issuer normally, then a Lehman subsidiary. And then the German regulator has ordered a specific audit. This was done by someone else, and we then were coming as advisors in addition. And the results of the specific audit had always been, yes, there has been an issue about product selection, and there's been an issue at the point of sale, but the formal rules at the point of sale had been complied with generally, and there had been no rules on the product pre-selection. Yeah? And then it ended up from the regulatory perspective with, so to say, non-leaked, or I think if it's Latin term, I mean nothing happened at the end. There were no kind of observations from a regulatory perspective which were serious. But on the civil law side, there was heavy kind of suffering from claims, and the courts were considering the claims against those banks. And this is I think, one of the reasons why product governance as a concept can really make sense and is not kind of an absurd idea. And I just have a slide when I attended a presentation from Chris Woolard, from a high-ranking officer from the FCA back in 2013, in the early days of product governance, where you already find this kind of distinction between these different tools and different themes of product governance intervention and then the point of sale rules. And when it says here, firms should place the customer at the heart of product design and governance, of course, this sounds good. And the question is, how can you do it in practice? And one of the points which just was striking my mind, to be honest, only quite later after I had first seen the slide is, and I discussed it in the morning with Andrew briefly, what kind of firm do they mean? You know, do they mean the manufacturer or do they mean the distributor? From this slide, you could possibly learn that they mean the manufacturer. And that's one of the interesting questions, and this is what I would like to try to discuss with you in a moment. You know, what is product governance really about? What was the idea and what has happened until now? And possibly 2 points in addition to this slide. You will not have found product governance rules in the first draft of MiFID II in October 2011. There was nothing in about product governance. But it was already mentioned in the consultation paper by the Commission for the MiFID review in December 2010. So it was already an idea which existed. And then it was not, you didn't find it was not included in the first MiFID II draft for whatever reason from the Commission, but then I think it was through the initiative of the Parliament in 2012, the idea of product governance then found its place in a little bit specific way in Article 16, mainly its way into MiFID II. And another thing, final word to this slide as regards the FCA, and this is what Andrew and I were discussing about. He said, look, from the FCA's perspective, and this was possibly, and please correct me if you know it differently from your country or elsewhere, the FCA was possibly the first national competent authority in Europe which has brought forward the idea of product governance. I mean, they had mis-selling cases quite a lot with products which are not kind of the normal financial instruments. You know, this was kind of payment protection insurances and I think it was derivative products for small and medium enterprises. But they have developed the concept already a few years ago, and it appears that they have really meant only structured products to be relevant for product governance terms. Structured products and manufacturers appear to have been the addressees of the initial product governance idea. And this has then, of course, found its way into MiFID II. As you know, if you look into the directive, Article 16, I think it's paragraph 3, and then you need to look into certain subparagraphs. Then you find some details, and then you look into the Delegate Directive, and then you look into what is the product governance guidelines from ESMA. Of course, we come to it also in a moment. And here again, my slide of looking at the different colors and looking at the completely colored picture, the two addressees of the MiFID II product governance rules, the manufacturer and the distributor, having in mind that a manufacturer of a relevant financial instrument, be it a fund, would not normally and necessarily, not necessarily be an investment firm, so that the one person which is being caught by the regulation in any event is the distributor. And in many countries, I believe it is the case that distribution is largely done by banks, for example, be it smaller or bigger banks. In other countries, they have independent financial advisors. In Germany, we have everything of these. but the bank networks are quite strong. And what are the obligations here? You know, what do the addressees need to do? And this is just for the purposes of not having any doubt about it. Okay, what does a manufacturer do? Manufactures products, sure. And what does a distributor do? And this is quite important just to keep in mind when you look into things like this. It is the intention to offer or recommend products or services. So the idea is generally that not only products are covered from the distributor side, but also services. Yeah? I always say when you are an investment advisor, for example, then you should need to make sure in the product governance rules and from a product governance perspective that you know why you are not offering portfolio management to your clients and vice versa, because this is normally an idea which you should kind of think about before you go to the market, and that's the idea of product governance. We see possibly later on how this works in practice, or you can tell me how this works in your practice, but this is the general idea. Yeah? And as regards products, of course, you know, there's an interrelation, there's a link, there's a working together, a necessary working together with manufacturer and distributor if these are two entities. And for the services, of course, this is only on the side of the distributor. And what I find also important is on this slide, you know, these are my two left areas. Each of them has an own kind of, is an own world for itself, so to say. And if these are two entities, they got two very different perspectives generally. The point of sale, which is in this kind of gray-brown color here, the point of sale, I'm still convinced about it, the point of sale was not a place which should be covered by and addressed by product governance rules, because this was and is governed otherwise, and even more than ever under MiFID II. Only this kind of ongoing monitoring, of course, and in a way changing and amending things is a part of product governance, but that the point of sale would be a part of product governance rules, I would find it as a clear overregulation. But we see also what the practice does with it. I find it quite important to look into recitals in MiFID II, because there you find not only the definition of research, as we have learned in the morning. Yeah, I mean, this is quite interesting that you find these important definitions or concrete issues in recitals. You also find, from my point of view, the real reason why product governance rules exist. And this clearly says, in order to avoid and reduce from an early stage potential risks of failure to comply with investor protection rules, investment firms should comply with product governance requirements. And therefore, for example, if you look at a target market exercise, when you only have an execution-only business as a distributor, and you face the target market requirements you may see and find in the product governance guidelines. From my point of view, having understood what the rationale behind is, you may tend to deal with it differently and possibly in a so to say, more kind of light way than in an over-engineered way. And you know, the respective roles, I just want to show you, different as perception and practice is, product governance should mean the one is coming with a product and the other one is coming with a client. And the target market is only one of various issues I would consider to be involved from the idea of product governance. The idea is that the manufacturer looks into the product. What kind of product am I attempting to bring to the market? And one of the relevant aspects may be a target market. But I understand practical implementation has tried to narrow it down to the target market, and then at the end of the day, and that's the reason why I haven't started with it, from my point of view, and just to say it now, the target market exercise and product governance as we see it, in a way as we see it being implemented and actually performed, does not bring any added value whatsoever. Yeah? And therefore I try to show you what the rationale behind could have been, and I was quite close to those people having thought about it and thought this brings certain kind of background value. And also the distributor doesn't only need to define an own target market generally and then kind of match it at the point of sale. It normally should have a look at one's own clients. And how could I and could we, and the next slide then hopefully is on the target market. I've understood from the beginning that if you introduce new rules like product governance and you address two different entities possibly, one creates a product and the other one has clients, concrete individual end clients. And we have implemented similar processes with clients even before MiFID II came into the game. And some of these clients have now abolished it under MiFID II because they think, oh, it's no longer relevant. You know, it was over-engineered. MiFID II requires much less. And I was a little bit concerned or at least disappointed about it. From my point of view, the idea was you do not only think from the product, you also think from the customer, because it is all to avoid that the customer gets unsuitable, inappropriate products, as we have seen in the recital. And this was the idea. Point of sale is governed as such, and we try to anticipate, we try to do things in advance. And for the manufacturer, it can just mean the way the manufacturer produces the product and anticipates any kind of market and client need. But it doesn't do it just in a theoretical way in its offices somewhere else, but it does it with a view to potential needs of clients. And the distributor does not just pick it up where it comes from the manufacturer who has a theory about clients. The distributor has a concrete idea about clients, and the distributor has clients and wants to have more clients. And what I've put as the individual actual client interest at the point of sale, you know, which you can call the suitability or appropriateness test, this could be anticipated in a more typical way by typical actual client interest. You could kind of try to aggregate, anticipate, and. And then as a distributor, you would match this with the things you get from the product manufacturer. So far the theory. What is the practice? The practice is, largely as far as I'm aware of it, that, and Esma has said, you know, this is only about the target market exercise, and if you look into the Delegated Directive, and if you look into the requirements for, I think it's Article 9 and Article 10, the requirements for manufacturers and distributors respectively, there are a lot of things governed, and you'll find about the target market, but it's not all about the target market. It's just among others. And ESMA then, and this was the discussion coming from the practice, let us talk about the target market only. First and then only. Yeah? And let's talk about the manufacturer dealing with the target market. And this was the way the discussion was taking. And this was only thinking together with the PRIPS implementation, thinking from the product and then into the direction of the end client. And the thinking from the customer has stopped at that stage. I think ESMA has tried to do the best out of it and to address all these things together, but please keep in mind, this is only, and this is quite a large piece of paper. I think the translations into national languages, including German, have just been provided in February, but this was already from June of last year. This provides very detailed guidance on normally just one piece of the exercise in terms of product governance. Yeah? You should do product testing, stress tests, and you should define a target market. But what you're doing today, you are only defining a target market. And ESMA, and you know all the criteria, how to define a target market. The German industry, various associations, mainly from the manufacturer side. And I should come to your point. The BVI is the German equivalent of the IFAMA. And I know that IFAMA, of course, and they have worked together, has also worked on this, and other associations have done. So the German fund industry, although they are technically not MiFID firms, they have from the beginning stepped in and said, look, we want to be part of the game, and our firms are going ahead with target market definitions. So the distributor is a MiFID firm in any event, otherwise it is not required to comply with these rules. And depending on whether the manufacturer is a MiFID firm or not, and ESMA has described it, and this is also described in Article 10 of the Delegate Directive, depending on whether your product manufacturer provides you with product governance related information, including the target market, you can use it, or you should use it as a distributor. And if this is not a MiFID firm, or even if it is a kind of a stock corporation which issues shares, they will never themselves define voluntarily define a target market. If the Federal Republic of Germany issues a governmental bond, they will never define a target market for this. In Germany, for example, we got research providers and others. They define it for the practice, and then you can use it as a distributor. So depending on, whether you get a target market in particular and product governance information, and you can communicate with a MiFID firm, you have a different exchange of information, and if it's a non-MiFID firm, of course, they are not required to comply with it, but they may voluntarily do as the asset managers, in my understanding, do. And if you look at the various parts of the target market exercise, and possibly that's the reason why I've not taken this as a, so to say, afternoon-filling topic, where do these kind of criteria come from? I mean, when considering how one could make a detailed program for manufacturers, for example, what could they do? They don't know the client. As ESMA has set it out, the manufacturer, and you find it here at the bottom left, needs to identify a potential target market because it only has theoretical knowledge and experience with a similar product without specific knowledge of individual clients. So you needed to come from the product, you needed to find criteria which you can then use as a distributor. And with a view to any potential investment services which may be provided at the point of sale. And as I said, if you got an execution-only business model at the point of sale as a distributor, and we discussed it to a certain extent over lunchtime, the only investor protection rules which may be infringed at the point of sale are those about the complex or non-complex instruments at the request of the client. This is clearly set out. An execution-only business requires only dealing with non-complex financial instruments. So what can you do when you are a manufacturer and you are acting together with execution-only businesses on the distribution side? You can only try to make sure that you produce non-complex products. You could not be required to consider anything about suitability or appropriateness, because at the point of sale and regarding the end client, this will never be relevant. But this has then evolved in a way that the manufacturer required, and I've discussed it also with IOPA because they had a different approach, the manufacturer, for the manufacturer, the need was seen to establish a separate and an own catalog of relevant criteria. And a mixture of things which are somehow logic, just the type of client, and a mixture of all the things which are relevant for later appropriateness and later suitability tests. You find here on the left-hand side, and it's similar to the German approach, of course, it needs to be in line with it. So this is, so to say, a best of any criteria which can be relevant at a later point of sale situation, but mainly and first of all for the manufacturer. And just 1 second, and as a result of this, and if you look, and I just made a kind of private market survey in January looking at a discount broker's website in terms of what are target markets provided like. And the target markets which are provided there are very, very generic. They are much more generic than the examples ESMA has shown in its Annex 5. And these are so generic that you can either do everything with it because it doesn't limit what you can do later at the point of sale, or you cannot use them for anything at all. What I want to say is the target market exercise is a very formal exercise. The way it needs to be done by the manufacturer is a very formal and very theoretical exercise, and I personally do not see a real added value in it the way it is being done now. I'm looking at the clock. We need to come to an end, and I need to get out of that. The last points here, the distributor, what I find quite important that the distributor's obligation, was not meant, and I try to bring arguments and reasonings to you that you can consider how you can, pragmatically and in a, so to say, purposeful sense apply those rules. And for the distributor, and I picked up these things from the Delegated Directive and the guidelines, it talks about a product approval process, a decision in advance of actually going to the market and going to the point of sale, the general decision-making process. responsibility from the very beginning, and it talks about the management responsibility there. And this influences all other relevant processes connected. So if you look at this, and if you pick up this language here, I think you could get a clue that for a distributor in particular, this is more than just taking the target market as it is and then putting it into your IT system and then matching it at the point of sale. I mean, if you look at you can read it afterwards, if you look at a more systematic view into the distributor's obligations, they tell you a lot of things which go beyond the target market. I have not done this for the manufacturer, I try to explain to you, but this again shows that, and I believe this will come in a certain quite close time. In addition, as soon as the target market exercise has proven to be just a very bureaucratic and technical exercise, and I've met no one in the industry, in Germany at least, who finds a real purpose in the sense, or in a sense in it, how it is actually handled. Because it's only costly. It's, as I said, it is at the end of the day an attempt to avoid to answer the strategic question, am I selecting the right products? Am I bringing the right products to the market by increasing complexity in terms of what is a target market and how I'm going to handle that? And I think that's the second to final slide then, and thanks for your patience here. Just if you take the example of distribution outside of the target market, I think this is the favorite topic of many people. What am I doing? And I remember the early stages of product governance discussions, and then it was quite clear that the target market is one thing, or the product governance rules are one thing, and at the point of sale, there the music plays, because there the client sits there this decision needs to be made, the investment decision. And the anticipation may have been good, but it may have been just not as good as it could. But here we find it, anticipation now sets, the boundaries for everything else that happens. For the distributor's pre-selection on a very technical and very formal basis of the target market criteria, and then at the point of sale in terms of matching the target market with the client information you have collected. In Germany, we call it the WPAG-Bogen, which is where you find all the client information. You have it in your system, you have the target market in your system, and then you match it. And this was normally not the idea. And by the way, the product governance guidelines normally shouldn't address this point. This should be addressed in the suitability guidelines. It is, to some extent, the case. But ESMA has provided some guidance about distribution outside of the positive target market. What does it mean? You can do it. It just needs to be justified. So far, so good. And if you have defined a negative target market and you are not only distributing outside of the positive but into the negative, then it says this should be a rare occurrence, second to last bullet point. And then ESMA has confirmed, and this is what I appreciate, and this is a very important point, that for the purposes of a portfolio approach, the target market then shouldn't be so important for an individual product. It should make sense from a portfolio perspective. And if you then look at processes which you need to have in an investment firm, the necessary processes, as far as I'm convinced, are the ex-ante process with the product pre-selection, which is more a kind of overview and kind of approach exercise, and then the ex-post processes where you have, of course, the information exchange and review and adjustment processes. And as we have learned, the point of sale has become, in practice to date, has become a necessary and unavoidable part of product governance processes, but makes the point of sale exercise even more cumbersome. And this is just finalizing it from a perspective, and I don't have the slide for the manufacturer, but it goes vice versa. It's Article 9, Article 10 of the Delegate Directive, where you find the responsibilities respectively of the management body, staff and compliance involved. And this shows that, as product governance says, I remember an investor protection day, I think it was 2 or 3 years ago, when Mr. Bernardino, the head of the IOPA, said, we call it product governance because it is linked to corporate governance. It is just a prudent part, a reasonable part, and any reasonable manager finds it immediately understandable that this belongs to the governance of the institution. at the end of the day, and I don't know really, and your feedback is much appreciated, partly you have already provided, thank you, that I try to highlight the difference between the theory of product governance, the idea behind, the purpose it can have, and the way, for certain reasons, it is about to be handled these days. And I believe that if we go on to handle it that way, it will prove to be just another bureaucratic, paper-killing exercise, which leads the way towards less investment services, less investment advice, and less availability of products. And this is when I found the concept fascinating a few years ago in the beginning. This was not at all what I had kind of brought together with what it may end up. So that's it for today. Thank you very much, and see you tomorrow.